Well, welcome everybody to our program today on the 2022 UCC amendments as recently enacted in Virginia, which will become effective next year. My co-presenter is Ed Smith with Morgan, Lewis, and Bockius in Morgan Lewis's New York and Boston offices. Ed was chair of the drafting committee for the amendments. I'm Steve Weise with Proskauer Rose in its Los Angeles office, and I was a member of the drafting committee. And Ed and I had several thousand phone calls during the drafting process with each other and others involved in the process. What we're going to do today is go through the effect of the amendments in Virginia and elsewhere in the United States to help you get ready. Importantly, as we go through this, we'll talk about the timing, the transition rules, and some relatively complex issues involving the period of time when the amendments are not yet in effect every place in the United States. It'll hurt your head for a while, and then those issues will go away as the states, the other jurisdictions in the United States catch up and get it adopted. So we'll update you on all of that. So we'll talk about enactment in Virginia and the status, why the amendments were done at all, the role of the Uniform Commercial Code as a matter of state law in dealing with digital assets of the kind covered by these amendments, why this came along, what the deficiencies were in pre-amendment law, and how the amendments fix all that, and some general thoughts. We'll have some new terminology for you. You see on the right side of the screen. We'll go through that in some detail as we work our way through the program. But there are some new terms to pick up, but we're also very careful in drafting the amendments to preserve, to the extent we could, existing terminology so that existing forms of security agreements and other documents could have only minimal amendments as you work your way through all of this. So it's somewhat detailed. Let me note that as you listen to us talk, if some of this sounds a little mystifying or complicated, we highly recommend that you read not only the amendments themselves, but the comments. The amendments are often, crisp and clean and short. And then there are pages of comments that explain how to apply the amendments in a series of circumstances. So the comments themselves are very valuable in working through how everything works, particularly when you get to some of these concepts like control or multi-signature arrangements and how that fits into control and things like that. We'll come back to all of that. But again, having a copy of the comments as you sit back at some point and work your way through this, I think will be very valuable.
Steve, I've been accused of saying, read the comments, and only if you see an ambiguity should you look to the statute.
That's probably right. It's not the first time that's happened with the UCC. The statute is really well done. Chuck Mooney, retired professor from Penn Law School, did a magnificent job following up on the earlier reporter, Steve Harris, who unfortunately passed away midway through the project. So Chuck's a terrific drafter, and the black letter is great, but the comments are super helpful as you work your way through this. So we'll pick up on some amendments to some definitions through the comments. The definition of money has changed. It's not going to be very important for a while. Definitions of chattel paper substantively are the same, but the definitions themselves are reworked to reflect what's really going on in the world. Some very helpful amendments, particularly for negotiable instruments and what qualifies as a negotiable instrument. Some amendments outside of the pure digital asset on payment systems. Amendments we'll talk about later on the meaning of the word conspicuous, the meaning of the word sign. You probably thought you knew that. As I mentioned before, some amendments on complex provisions, unfortunately, but that's the way it is. On transition, some more information on enactment status around the country, and again, the choice of law issues. So we'll be going through all that in some detail. And if you have questions as we go along, feel free to use the chat feature to send questions, and we'll try to respond more or less in real time. The amendments have been enacted in Virginia. They'll become effective July 1 of next year. 24 states and the District of Columbia have adopted the amendments. We'll provide a list of those later on in the program. And as we'll explain, there are some potential issues, or not issues, but difficulties in working through how to apply the amendments during the period of time when not every place has adopted those amendments. So Ed, on to you. Why did we do this?
Yeah, why are we inflicting this on all of you? There were a lot of issues that people have had with the pre-amendments Uniform Commercial Code. There was a lot of concern that the Uniform Commercial Code had not been keeping up with technological developments. And there were two areas in particular that really pushed us towards having this sort of amendment process. One was dealing with virtual currency. Now, I'm not talking about money, I'm talking about Bitcoin and Ether, stable coins and the like. These are general intangibles under Article 9. And there is no real adverse claim cutoff rule for a buyer who buys cryptocurrency. Cryptocurrency under pre-amendments UCC are not negotiable. And even though people treat virtual currencies as money, they don't really act like money because there could be a third party who has a property interest, including a security interest in the virtual currency, and the buyer would take subject to that. And then there were a lot of lenders who were lending against cryptocurrencies, and they were finding that just very inconvenient because cryptocurrencies being general intangibles, the only way to perfect would be by filing a financing statement. If you want to be in first position, you've got to do a UCC search and get a subordination or release from someone who has already filed ahead of you. If you're dealing with someone whose location may move from time to time, like you're lending to an individual, the individual moves to a new state, you need to file a financing statement in the new state within 4 months, so you need to monitor. This was a big problem. Now, there is a workaround. The workaround is for the cryptocurrency to be held at the custodian or exchange and be treated as investment property under Article 8. So you could run victory laps saying, hi, I solved this problem. I just turned this cryptocurrency from a general intangible into a security entitlement. But the same issues apply when you think about the custodian or exchange acquiring the cryptocurrency for credit to the securities account. There needs to be some adverse claim cutoff rule. So that was one area. The other area that was big, and we go to the next slide, is trade finance, especially during the pandemic. We found that there was a lot of desire for parties to conduct business electronically, and in the trade finance area, using electronic promissory notes and electronic bills of exchange. This really didn't work very well under the pre-amendments UCC. If you want to have a negotiable instrument, it needs to be in writing under Article 3 of the UCC. And although there are provisions in e-sign and the Uniform Electronic Transactions Act for transferable records, there are fairly rigid requirements for transferable records. You've got to say, this is a transferable record. You've got the terms have to be such that if they were reduced to writing, that the writing would qualify as a negotiable instrument under Article 3. And even though people wanted to use even the transferable record provisions, they couldn't be sure that they might not end up litigating in a jurisdiction that has not adopted, let's say, the Uniform Electronic Transactions Act transferable records provisions. So there was a need for greater clarity on choice of law and choice of forum clauses in these electronic instruments. So let me just remind everyone how the UCC fits into this. Commercial law, of course, has been largely left to the states. We have contract law among private parties, but then we have the Uniform Commercial Code that's been adopted in substantially uniform form before the amendments, at least, in 50 states and the District of Columbia, dealing with sale and lease of goods, negotiable instruments, payment systems, documents of title, letters of credit, investment securities and secured transactions. State law also has a role in enforcement of claims, contract claims, and claims under the UCC. And then also there are state fraudulent transfer laws. But insolvency law has been largely left to federal law, especially the bankruptcy code. So the project itself, Steve and I are members of the permanent editorial board for the Uniform Commercial Code. We were the ones who were getting this pressure from states. We were also seeing some states trying to enact non-uniform provisions of the UCC to try to deal with these issues. So we knew that we had to get our act together. We went to the sponsoring organizations, the American Law Institute, the Uniform Law Commission, and started a study committee process in 2019 that quickly turned into a drafting committee process. We had drafting committee members from the American Law Institute and the Uniform Law Commission. We had advisors from the American Bar Association. We had observers across the country and even the world. Most of our meetings were done virtually since it was during the pandemic. I think 13 out of our 15 meetings were done virtually. So we had participants dialing in from all sorts of countries wanting to know how we were going to handle these issues so that they can deal with it in their own countries by way of law reform. And at any one time in our meetings, we could have up to 100 people on the call. It was like dealing with the cast of Ben-Hur. But we went through a number of different drafts and finally came up with final products that were approved by the American Law Institute and the Uniform Law Commission in 2022. And then we started the state introduction process. Now, there are some general themes that we tried to follow throughout this drafting process. One was we were aware that the technology was changing very rapidly and we were always trying to catch up. We wanted to examine the entire UCC, not just those areas dealing with virtual currency and trade finance where there was the most market pressure. We wanted technological neutrality. We wanted to make sure that we were drafting not only for the technology we know today, but the technology that could exist in the future, just like we saw with the Uniform Electronic Transactions Act that was enacted 2 decades ago and still works. And so we didn't want to also change policy, make big policy choices unless they were justified. Some other themes, there was no preference really given for whether a digital asset was held directly or indirectly through an exchange or custodian. We were agnostic on that issue. But then there were some issues that arose that were troublesome in practice or from court decisions that really didn't deal specifically with technology, but we thought that we could address those issues as part of this amendment process. We're aware that there is rapid change in other legislation, especially regulatory changes, but this was not a regulatory statute. We also were thrown a curveball that we'll talk about when El Salvador adopted Bitcoin as fiat currency, making, we think, Bitcoin money under the UCC rather than a general intangible. But that's the background. So now let's get into the substance. And Steve is going to start us off with what a digital asset is.
Thank you, Ed. And we're all, of course, quite familiar with the notions of digital assets these days. And digital asset is something that's electronic in an electronic record as opposed to a paper record. Record is the word that it substitutes in modern days in the UCC for what one used to think of as a paper document. The word record encompasses whether it's paper, tangible, or electronic in some form. And it's just information, as the quotation from the statute there, that's inscribed in a tangible medium or stored in electronic form that is retrievable in perceivable form. So if you can call it up on a computer screen, if you can listen to it, if the human senses, one of your human senses can be invoked to perceive the information, then it's going to be a record for these purposes. As we'll see in a few moments, there's a subset of electronic records that are specifically dealt with by this legislation, but we'll come back to that in a moment. The phrase digital asset has the word asset. The asset may or may not have value. If you have a paper contract to, to receive goods, whatever value that might have is the same value it would have if it's an electronic contract. Possession of the paper as such, outside of things like negotiable instruments, don't necessarily give you any rights. If something is assigned, then it may give you some rights, and the same kinds of rights, the same sets of rights, the same value or lack of value in those rights is the same, whether it's paper or electronic. So if somebody sends you an electronic copy of a record, of a contract rather, whether that gives you any value in the absence of assignment is the same for comparable kinds of paper records. As Ed referred to before, we've got non-government digital virtual currencies, rather, like Bitcoin, and value is attributed to those. Then we have non-fungible tokens. You have some electronic record that may or may not be linked or tethered to some other tangible item, for example, a painting or whatever it might be, a piece of real estate, and the value of that depends on how the law treats the tethering and whether it recognizes it or not. So it's sort of a lot of open questions, as that is referred to a few times. The Uniform Electronic Transactions Act created a relatively narrow set of electronic records called transferable records, which embody in a reification sense the right to payment of the relevant electronic set of rights, but a lot was lacking in terms of how to address and deal with other kinds of electronic records. So as we developed the thinking about amendments to the UCC for digital assets, the original primary driving goal for the core of the amendments was to have something akin to a negotiable instrument or something akin to a security under Article 8, certificated or uncertificated, that would give transferees the kinds of take-free rights, cutting off claims of third parties that exists for a negotiable instrument under Article 3 or exists for a security for a protected purchaser under Article 8, or for the rough equivalent purchaser if the transferee is obtaining a security entitlement or a securities account under Part 5 of Article 8. As Ed said before, virtual currencies as general intangibles under the UCC and intangibles in general under the law had no benefits of take-free rules. If you're if you acquire a negotiable instrument and you have it delivered to you, and there's an endorsement and you didn't have notice of adverse claims and things like that, you took free of those claims. Similarly, for securities under Article 8, there is nothing like that for Bitcoin or other intangible rights, including anything that embodied a right to payment. So our goal was principally to create a set of rules that were similar to the rules for negotiable instruments or securities, or in some senses, buyers in ordinary course of goods under Article 2 and parts of Article 9, so that these would trade with more freely and with more certainty in commerce and get around, as Ed described, the inefficiencies of negotiable instruments and pieces of paper and warehousing them and transferring them and all these, excuse me, great rules in Article 3, but way out of date in terms of how the real world works today. So we'll get into more detail of that momentarily, both for purposes of outright transferees of these specific kinds of digital assets, as well as a security interest in these kinds of digital assets. Much more detail to come. The amendments do not answer all legal questions about these kinds of digital assets. The question of regulatory rules for all of them, not covered, not our job, and mostly federal law. Taxation, again, mostly federal law. Lots of states have rules on money transmission laws, again, not covered by this. This is not a regulatory statute. This is a trade these items, these assets in commerce kind of statute. And similarly, the regulatory aspects of anti-money laundering not covered. Other laws will cover that. We did not try to answer every single question. So Ed, there are other projects going on at the Uniform Law Commission. Tell us about those.
Yeah, the good news is there's no real conflict between these amendments and these other projects. There is a Uniform Regulation of Virtual Currency Businesses Act. That's a regulatory act at the state level for exchanges and custodians of digital assets. There's a supplemental commercial act to that deals with protecting users of those assets. And then we have the Uniform Electronic Transactions Act. And what we're going to see is that if someone wants to continue to use transferable record provisions under the Uniform Electronic Transactions Act, that's fine. That's outside the scope of what we're going to talk about in the proposed Article 12. So not really an issue. But now we're coming back to Steve again to talk about a subcategory of digital assets that we call controllable electronic records.
Thanks, Ed. And here's where we're going to get, for the first time, deeply into the substance of the amendments. Controllable electronic records is a core concept in Article 12, as well as the amendments in Article 9 to deal with perfection and priority of security interest in these kinds of digital assets. So the discussion starting now is quite important. And again, coming back to the comments that Ed and I mentioned several times, that'll be very important to look at the comments to help you understand how to apply these particular definitions, this particular terminology as we work our way through all this. So I've already discussed a little bit the meaning of a record. A record is information inscribed in a tangible or electronic medium that is perceivable, is retrievable in a way that is perceivable by a human being. So we've got electronic, it's set in the middle word in this term. So electronic modifies the word record. And as I said before, record can be tangible or electronic. We've now shaved off the tangible part of record for this purpose. So we're dealing only in these provisions with electronic records. There's a nice definition of the word electronic used in various places in the UCC, but it means what you expect it to mean. no big surprises there. Where it gets complicated, and we'll give you a lot more detail on this in a moment, is the meaning of control. So you see, go back to the title on this slide, controllable electronic records. So the question is the electronic record subject to control as the word control is defined in the UCC, and we'll cover that in some detail in the very next slide. We'll come back to that again in just a moment. So is it susceptible of control based on the structure of the electronic record itself? If the electronic record is not susceptible of control, then it's still an electronic record. It's just not covered by the definition of CER, and thus it's not covered by Article 12's rules on CERs and take free of property claims and shelter rules, which we'll come back to in a couple of moments. But it's still a general intangible. You can still create a security interest, excuse me, in it under Article 9 as a general intangible, but not as a controllable electronic record, where we have some special rules in Article 9 that apply only to controllable electronic records. And again, we'll come back to that. So the application of what Ed and I are mostly talking about today is critically tied to controllable electronic records. You'll see in the comments some helpful discussion of what's in, what's out. Is your Facebook page or your Instagram page a controllable electronic record? And if the comments explain why they're not a controllable electronic record. So it takes all of us by the hand, walks us through all of this. And I should add, as Ed talked about the many observers we had during the drafting process, it was critically important that we had observers not from the world of the UCC, but from the world of digital assets and distributed ledger technology transactions. And Ed and I and the other UCC folks would come up with an approach that we thought made sense as a commercial law matter. Then we would turn to the electronic digital assets observers and say, does this work? And they would say, well, components 1, 3, and 5 work, but 2 and 4 don't make any sense because we can't make that work in our context. So we play with it and come back, and we worked with them, which was critically important in making sure all this worked, both from a commercial law point of view and from the point of view of lawyers and people, business people who own and trade digital assets in commerce. We also recognized in the last set there that we didn't need to rewrite everything. There were already plenty of rules in the UCC that dealt very well with other assets that could fall within the definition of a controllable electronic record, but we didn't need to do that because the rules were just fine. So we have rules for chattel paper in electronic form. We do have some amendments to that to sort of clarify and make it work a little better, but the fundamental approaches are there. Electronic documents, Article 7 was revised, 15 years ago and ably addresses much of that. Article 8 on investment property and how to opt in already deals with uncertificated securities and securities accounts, which are intangible. No need to rewrite all of that. There are some very helpful comments. There's some activity out there of how you deal with an intangible security. Is it certificated? Is it uncertificated? The comments explain why an intangible or electronic security is not a certificated security. It's an uncertificated security. There's nothing wrong with that because the rules in Article 8 for uncertificated securities closely parallel in the results you would get for a certificated security. You just want to understand what you've got and what the applicable rules are. We've referred a few times to transferable records under the Uniform Electronic Transactions Act and its federal equivalent, e-sign. No need to change that. Deposit accounts are inherently intangible, so clarifications were added on that. More about that later. And electronic money also more about that later. So the key addition in all of this is this notion of control, which, as I mentioned, is the first word in that three-word defined term, controllable electronic record. So let's assume we've got a record. It's information in electronic form that's perceivable. It's electronic record. So what does control mean, or controllable, which of course is derived from the word control? We have a lengthy definition in Article 12, and that same definition you'll hear about later in perfecting a security interest in the CER. And the word control is defined in Article 9 by incorporating the definition in Article 12. This is a critical term in all of these amendments, and it has various elements. It has the person asserting control has to enjoy substantially, not all, but substantially all the benefits of the CER. It does not have to be exclusive. You'll hear the word exclusive a lot in just a few moments as to other aspects of the definition of control. But so it's the benefit. There has to be some sort of use there. For example, the power to spend Bitcoin is a use, and the person asserting control has to have substantially all the benefits of that particular use for something like Bitcoin. The person also, these are a series of ands, the person also has to have the exclusive power to prevent others from enjoying substantially all the benefits. So let's take Bitcoin as an example, but not everything's going to be like Bitcoin. And as we'll talk about later, there are rights to payment, controllable accounts, and controllable payment intangibles that are not similar to Bitcoin, where all these same rules apply, and we'll come back to that in a few moments. So in Bitcoin, we've got the public key, we've got the private key. Presumably, the person asserting control is the only person that has the private key, or it's held in addition by others whom that person is working with. So if, take an easy example, if that person is the only person that has the private key, it's the only person who can get any benefit out of it, because you need the private key to transfer the Bitcoin, for example. So that person would have the exclusive power to prevent others from enjoying the benefit, because anybody who doesn't have the private key, or the equivalent for other kinds of controllable electronic records, can't enjoy any of the benefits of the CER. Similarly, the person asserting control has to have the exclusive power to make transfers. And again, if you use the private key example for Bitcoin, that's going to apply in those circumstances, because somebody without the private key cannot make any transfer of the Bitcoin. And then the transfer, when it occurs, would divest that person as the Bitcoin is transferred to somebody else's wallet, for example. Another component, and again, each of these must exist, is the person asserting control must be able to identify itself to a third party as the person having these powers, so that a potential transferee would be able to get comfortable that they're getting a transfer from the person who does have these three kinds of benefits or rights. There's substantially all the benefit, exclusive power to prevent others, exclusive power to transfer. And all of this was vetted, as I said a few moments ago, with our observers from the digital world, who were not necessarily UCC types, but understood backwards and forwards all of the rules for transfer digital assets and how all that worked in the real world, rather. One concern these folks brought to our attention, and we developed some complicated rules on how to deal with it, is that sometimes there will be more than one person that has the private key. Ed and I might buy some Bitcoin together, and Ed and I have an agreement, and it's set up so that only Ed and I working together, we each have to use the private key to make a transfer. Then how does control work there in a multi-sig relationship? What if Ed can transfer on his private key alone, but I can transfer only if Ed works with me. In that context, in the multi-sig, Ed has control because he doesn't need me, but I may not have control because I need Ed in that circumstance. So there are a lot of variations on all this. And again, the comments and the illustrations are extremely helpful in working through when control exists in these so-called multi-sig relationships. These are very common. And again, take a look. As a practical matter, we think, excuse me, they're going to work very well. So once you've established that you've got a CER and that it's controllable, we then come to the key provision of Article 12, the qualifying purchaser, the take free, and the shelter rules, and Ed will walk us through that.
All right, so you have a record. It's an electronic record. It is subject to control. So what? What does that mean? Why do we care? So if I have control of a controllable electronic record and I transfer it to Steve so that Steve now has control, Steve acquires under Article 12 all rights that I had in that controllable electronic record. Now, it could be that my rights are fine, that I'm the owner. This controllable electronic record is not encumbered in any way. But if I'm not the owner, if I had hacked into someone else's system and stolen this controllable electronic record and then transferred to Steve, who obtained control, Steve would take subject to the rights of the owner. So how do we deal with the take free part of this? We have a super transferee, someone that we refer to as a qualifying purchaser. And that person does take free of adverse property claims to the controllable electronic record. Now, what is a qualifying purchaser? That's someone who is a purchaser, of course, is defined in the UCC, who obtains control of the controllable electronic record for value and in good faith and without notice of a property claim in the controllable electronic record. And just because someone had filed a financing statement against the controllable electronic record is not notice of the property claim to the CER. So you could have what we've done then is essentially made the controllable electronic record negotiable, just like, as Steve said, a negotiable promissory note or a certificated security. You have the ability to take free of adverse claims if you are a qualifying purchaser. So the combination of the shelter rule, that Steve acquires all the rights that I have in the controllable electronic record, and the qualifying purchaser rule, which means that if Steve is a qualifying purchaser, he takes free of any adverse property claims to the controllable electronic record, are really key to making Article 12 work. So then sometimes you have a controllable electronic record that has embedded in it some other right. Up till now, we've been talking about controllable electronic records that have their own intrinsic value, like cryptocurrency or non-fungible tokens. But occasionally you'll find that there is some other right that is evidenced by, embedded in the controllable electronic record. And for that, we refer often to the phrase tethering. And Steve's going to talk to us about tethering.
Thank you, Ed. And some misunderstandings out there in the world about how the non-fungible token, the NFT, that's arguably tethered to some other item of value, a painting, a piece of real estate, stock, franchise right, whatever it might be. And the question is, how does all that work in connection with the qualifying purchaser and the shelter rule that Ed just described. And as you'll hear in just a moment, Article 12 and the Article 9 amendments do not address this in general. There's two very important subsets they do address, but in general, they do not answer the question of whether having an NFT that is supposed to represent or be tethered to a Monet or Blackacre or something like that actually is tethered in that sense. Does it transfer ownership of that other item of property or not? Other law is going to answer that question. UCC, except for the examples we'll talk about in just a moment, does not answer that. So if you see a transaction where someone says you buy this NFT, you get it transferred to you, you get control of the NFT, bingo, you own the Monet. Don't look in the UCC for an answer as to whether you actually own that Monet. You may have contractual obligations of the person who issues the NFT to get you the Monet, but it doesn't mean you've got the Monet in those circumstances. And there's been a study committee which has decided at the Uniform Law Commission about NFTs and real property and how that works. And I think the decision has been to put that off for a while until more develops in this area. So be very cautious as you look at these outside of the two I'm about to talk about that have been brought into the UCC, and those are what we call controllable accounts and controllable payment intangibles. And what we've got is a concept of account, this classic traditional definition of account in 9102, a right to payment of money for the provision of property or services, plus some other parts of the definition. Payment intangible is a subset of general intangibles where the principal obligation of the account debtor is to pay money. So it could be a loan agreement not represented by an instrument, for example. So when an account or a payment intangible is evidenced by a CER, same definition we've just been talking about at length, and the debtor, the account debtor, the person who owes the account or owes the payment intangible, has agreed to pay the person in control of the CER that evidences the account or the payment intangible, then we have what we call a controllable account or a controllable payment intangible. So, for example, if a sales agreement or a security agreement refer to all accounts or all payment intangibles, they would include controllable accounts and controllable payment intangibles because those are subsets of the broader category of account or payment intangible. The magic that the UCC provides in this tethering concept is that as a matter of statute, when the CER that evidences a payment intangible, a controllable payment intangible, or a controllable account, when that CER itself is transferred and the transferee of the CER meets the qualifying purchaser or the shelter rules that Ed described a few moments ago, then the take-free rule applies not only to the CER, the qualifying purchaser rule, but also applies to the controllable account or controllable payment intangible that is tethered to that CER. So the controllable account and the controllable payment intangible itself is not a CER. They're either an account or a payment intangible, but by the account debtor agreeing to pay the person in control of the CER, and by having the CER evidence the controllable account or the controllable payment intangible, the qualifying purchaser and shelter rules embedded in Article 12 apply also to the controllable account and, or the controllable payment intangible. So in effect, what these rules do is it extends the treatment to those kinds of assets of, what you would have for a paper negotiable instrument under Article 3, and in effect creates many, not quite all, we'll come to the next bullet, creates many of the characteristics, creates all of the characteristics of a paper instrument in the sense of a holder in due course under Article 3, taking free of claims, property claims, to that instrument. So the rule that Ed described a minute ago for qualifying purchaser, which applies to the CER, applies equally to the tethered controllable account and to the tethered controllable payment intangible, creating these rights to payment, which if someone is a qualifying purchaser, they take free. What all this does, going way back to why this project started, as Ed described a little while ago, it facilitates trading in commerce these rights to payment without the cumbersome aspects of paper and negotiable instruments and trade drafts and things like that, which are just inefficient, create friction, create costs in transaction sense. All of this can happen instantly in transactions. All this information is maintained electronically, and there's no delay in what's going on. Now, the one aspect that as such doesn't come with all of this that a negotiable instrument has is that outside of consumer transactions in Article 3, if somebody is a holder in due course of a negotiable instrument, they had it endorsed to them, they didn't have notice of the claim, and they have possession directly or indirectly, then the defenses of the obligor on the negotiable instrument, most defenses are cut off. That is not included in the Article 12 amendments, but it can be included by contract in the controllable payment intangible or the controllable account. So if you combine Article 12's tethering and take free rules for controllable accounts and controllable payment intangibles, and you combine that with contractual agreement not to assert defenses, again, outside of consumer transactions, all sorts of state and federal regulation of consumer transactions, then you've got the electronic equivalent of a paper negotiable instrument, because when you work your way back through the definitions in Article 3, you'll see that a negotiable instrument under Article 3 has to be on something tangible, usually paper. I suppose you could inscribe it on a big rock and deliver the rock to the transferee, but you don't see that too often. So critical key benefit of the revisions to the UCC. So how do we deal with the account debtor, the person that owes the account or the person that owes the payment intangible? We've got some rules, existing rules for negotiable instruments in 3602 and in Article 9 for accounts or payment intangibles, excuse me, in 9406. But it's a little bit more complicated here because a lot of these things are happening online. There may be some anonymity. People may not be as sure as how to deal with this online. It's one thing to call up somebody and say, why do I owe you the money instead of the bank in whose favor I signed that negotiable instrument? So there are special rules on how the account debtor deals with discharging its obligations. Recall that the definition of controllable electronic record and then the controllable account and controllable payment intangible requires that the account debtor, the person that owes the money, has agreed to pay the person in control of the CER that evidences the controllable account or the controllable payment intangible. How does that person know who's in control of all of those things? The rules provide, similar to 9406, that the account debtor can pay the person originally in control until it's received appropriate notice that a control has been changed. The account debtor is entitled to request reasonable proof that control has been transferred. Recall back in the definition of control, one of the requirements is that the person asserting control has to be able to demonstrate that it has control. So that ties back in to this. This was all drafted as a package and work through. So that's why that one of the reasons why that requirement of being able to demonstrate control is there. So the account debtor, when it requests reasonable proof, can get that kind of proof. And then all the process for demonstrating how control exists has to be agreed to by the account debtor in an authenticated record. Actually, that should probably be a signed record now that I think about it. And we'll talk about the meaning of the word sign when we get to it, but in a record with the person in control and how the information about proving control is going to be provided. So when the controllable account or controllable payment intangible is established to begin with, this record would be created, this agreement would be created in some manner at that time. And then finally, on tethering and how all of this works, there will be, the anticipation is that there won't be changes in payment directions, that people's experience in the pre-amendment days of account debtors asking for proof is that account debtors rarely ask for proof and they sort of accept what they get. Occasionally, we've made reasonable requests for proof when I get a call from one of my colleagues who says they owe money to X, and instead of X, Y is demanding payment. What do we do? I introduce them to the provisions of Part 4 of the UCC and how all that works. So the agreement on how all this is to be demonstrated, I referred to a moment ago, is the protection for the account debtor and how it's going to get that information. So you may have thought that studying for the bar exam was one of the last times you'd have to think about choice of law. But we've got, because of the electronic nature of this and the absence of an actual location for something that's intangible, some detailed choice of law rules, and Ed's going to walk through those. And I think you're on mute, maybe.
Yeah, thank you, Steve. Let me give you a break for a minute. About choice of law. This was probably one of the most difficult issues we had to deal with. It's one thing to create the substantive law that each state would adopt, but then how do you make sure that that substantive law gets applied no matter where a dispute arises? So we needed to have some sort of way for a court in the forum jurisdiction to figure out which state's substantive law applies. And that's important not only as each state adopts these 2022 amendments, but also for cross-border transactions. We all recognized that trading in controllable electronic records and controllable accounts and controllable payment intangibles is worldwide. So how can we maximize the likelihood that the substantive law rules that we just talked about will be applied in a particular court? So let's go to the basic rules for choice of law. We have a waterfall. And even though, as Steve said, the controllable electronic record might not have any physical location, we have a fictitious CER jurisdiction. This is very similar to what we do in Article 8 for uncertificated securities, for example. We have a location rule. So if you have the controllable electronic record that says that the state of X is the CER's jurisdiction, then you look to the substantive law of that jurisdiction to determine the applicable rules. If you don't have that sort of language in the controllable electronic record, but the system in which the controllable electronic record has such a term, say this is the State X is the CER's jurisdiction for all CERs that are recorded on the system, and that controls. If you don't have either of those, all you need then is a general choice of law rule in the controllable electronic record. If the controllable electronic record says this record is governed by the law of state X, then you look to the law of state X for the substantive law rules. And if that doesn't work, but the system in which the controllable electronic record is recorded has a general choice of law term that says all controllable electronic records recorded on the system are governed by the law of X, you look to the law of X to determine the substantive law rules. Now, we recognize that it may be a long time before some of these controllable electronic records or systems have a reference to a CER's jurisdiction or even a governing law clause. You won't find that, for example, with Bitcoin or Ether. So we needed some other residual rule here, fallback rule, that would maximize the possibility that the substantive law rules of Article 12 would apply. So we said, well, look to the law then of Washington, D.C. This is very similar to what a lot of you are familiar with in Article 9, when you have a foreign debtor whose jurisdiction where it has its chief executive office doesn't have a UCC type filing system. The debtor is deemed to be located in Washington, D.C. Well, here we have the CER's jurisdiction as deemed to be located in Washington, D.C., assuming that Washington, D.C. has adopted these amendments. If Washington, D.C. has not adopted them, then you just apply Article 12. But mercifully, Washington, D.C. has adopted the 2022 amendments and done so on a uniform basis. Now, the only slight exception here to these choice of law rules relates to the relationship between the debtor and the account debtor, the person that's obligated on a controllable account or controllable payment intangible. The choice of law rule to determine the rights and obligations of the account debtor in that situation would be governed by the law that governs the relationship between the debtor and the account debtor. So we don't want the account debtor, for example, to be subject to rules that the account debtor didn't agree to in its contract with the debtor. But that's the only big exception to the Article 12 choice of law rules. Well, we've been dealing with Article 12, which really addresses sales of the controllable electronic record, but we have a whole nother area that's of interest to, I think, many, if not most of you, which is taking a security interest in a controllable electronic record or controllable account or controllable payment intangible. And Steve's going to tell us about secure transactions.
Thanks, Ed. As Ed mentioned before, rather, when we did the revisions to deal with assets, we looked at the entire UCC. We wanted to make sure that, for example, something we put in Article 12 would not mess up something that's in another article of the UCC, in particular, Article 9 of the UCC on secured transactions. So there was careful coordination and detailing, and to the extent possible, which was a very great extent, sharing of definitions and processes and things like that, so that if you do what you want to do under Article 12, you're going to be in pretty good shape under Article 9 if you're taking an Article 9 security interest in a CER. So the CER itself is a general intangible. It's that just some information in the controllable electronic record. As I mentioned before, a controllable account is still an account. Controllable payment intangible is still a payment intangible. So if you take your form of security agreement, which you last revised in 2005, and it creates a security interest in all accounts and all general intangibles, then you've got a security interest in all CERs. You've got a security interest in all accounts, including any controllable accounts. And you've got a security interest in all general intangibles, including payment intangibles, which are a subset of general intangibles, and further including all controllable payment intangibles, which are a subset of the subset of payment intangibles. So you're in good shape. And even if you haven't sat down and studied all this, at least as to creation and attachment of the security interest, you're going to be fine. And you will have described what you need to do. The requirement for attachment will be the same. The value has to be given. You need a signed, and we'll come to the meaning of the word signed a little later, security agreement. With some exceptions, you can have an oral security agreement if the secured party has control of the controllable payment intangible, the controllable account, or the controllable, the CER itself as a method of perfection will double. Unlikely in many cases, you're going to do transactions where you intentionally have only oral security agreement, but you never know. And these are similar to the rules already in 9203 that in lieu of a signed security agreement, if the secured party pursuant to an oral security agreement has possession of the goods, possession of certificated security, possession of other kinds of items that are subject to perfection by possession, then that can substitute for all of that. So where the key changes arise are in perfection. As a general intangible, an account, or a payment intangible, it's still possible to perfect a security interest in these kinds of assets by filing a financing statement, the good old-fashioned financing statement. The description of the collateral, the indication of the collateral in the financing statement can say all accounts, it can say all controllable accounts, whatever you want to do on that. Similarly, all general intangibles, all payment intangibles, all controllable payment intangibles. Or, and here's the big change, a security interest in a CER, a controllable account, or a controllable payment intangible can be perfected by control. Now, notice that the perfection by control of a controllable account or a controllable payment intangible is accomplished by obtaining control of the CER itself, not by getting control directly of the controllable account or the controllable payment intangible. Obtaining control of the CER that evidences the controllable account or the controllable payment intangible as a matter of law under the definition of control in Article 12, which is used in Article 9, gives the secured party control of the controllable account and the controllable payment intangible. And indeed, you don't even need a security interest in the CER itself. You can get a security interest in the controllable account or the controllable payment intangible, and then without a security interest in the CER, but control of the CER, there is control of the controllable account and the controllable payment intangible. When I talk about this, I feel like I'm talking about Peter Piper picked a peck of pickled peppers, because the word controllable keeps coming up over and over and over again. So I think most secured parties will probably take a security interest in the CER as well as the controllable account and the controllable payment intangible. But you don't have to. And again, you'll see all of this explained in the comments as well as provided in the statute. Now, if one secured party obtains perfection by filing a financing statement and another secured party later in time perfects by obtaining control of the CER and thereby getting control, you can stop with the CER. There doesn't have to be a controllable account or a controllable payment intangible. So if it's Bitcoin, which is a CER without need for these tethering rules, you get control. You do get a security interest in the CER because that is the collateral, and you get a control of the CER. You're all set. And if one secured party perfects in the Bitcoin by filing a financing statement, and then the following week another secured party perfects in the CER, whether it's Bitcoin or whether it's indirect perfection in the controllable account and the controllable payment intangible, the one who has control has priority, even though later in time, over a secured party who does not have control of the CER. So in transactions, going back to the purpose of all this, where real-time trading in these assets is occurring, someone is going to sell or grant a security interest in the CER, the controllable account, or the controllable payment intangible. The secured party doesn't have to check the filing records. As Ed mentioned, the filing of a financing statement is not, for these purposes, notice of a third-party property claim in the CER. Instead, if they get control, then they're going to have priority, even if they're not a qualifying purchaser. This is not a qualifying purchaser rule. They could also be a qualifying purchaser, but for which covers not only other security interests, but other property claims to the CER or the controllable account or the controllable payment intangible. But as a pure matter of Article 9 priority, without regard to notice or anything else, the secured party with control is going to have priority over a secured party without control. So this is the huge benefit in Article 9. As we've said several times, the meaning of control is defined by reference to the definition of control and all those substantial and exclusive rights that we talked about a little while ago in the definition of control. So this is the big change in Article 9. So now choice of law pops up again. Just can't ignore those choice of law rules. And again, for purposes of integration of the rules between Article 9, Article 12, other articles of the UCC, it's the same choice of law rule as Ed described in Article 12, with one exception that I'll get to for a moment. So, and this will come up and cause headaches when we get to how to deal with choice of law during the time when the not all states or jurisdictions in the United States have adopted the revisions. But assuming the revisions do apply in your circumstance, then the choice of law rule, the CER's jurisdiction rule, will apply for perfection and priority of a security interest in a CER, not creation. Creation under the prior law was governed by the 1301 rule. The parties typically agree on what state's law is going to apply. And if that's enforceable under 1301, then it'll be enforceable under Article 9. So the CER's jurisdiction, assuming it has adopted the amendments, will govern perfection and the control rules and the non-temporal priority rule I mentioned. The exception to that is that the pre-amendment rule for where you file a financing statement, which is at the location of the debtor, we're all familiar with that rule for 25 years now, will continue to apply for perfection by filing. But the priority of the security interest will be governed by the CER's jurisdiction. And that's true even if no one has control. If two secured parties have filed a financing statement describing general intangibles and picks up some CERs or controllable payment intangibles, the filing of the financing statement at the debtor's jurisdiction, will perfect the security interest, but the priority of that security interest will be determined by the CER's jurisdiction, even if there's no control issue floating around at all. And that's because we need to have the same set of rules for priority apply to the qualifying purchaser rules over in Article 12. You can't have a dislocation between the application of those two sets of rules. Now, once all the states and jurisdictions in the United States have adopted this, it won't matter because you'll have the same results every place. But as we'll get to in a few moments, briefly, during the period of time when not everyone has it, this could make a difference in how all that works out, and we'll explain that in a couple of minutes. So Ed, you referred to El Salvador and money. How does money work in all these new rules?
Money. So if you look to the pre-amendments definition of money, in Article 1 of the UCC, you'll find that it's a medium of exchange that is authorized by a domestic or foreign government. So when El Salvador and the Central African Republic decided to adopt Bitcoin as a fiat currency in those countries, Bitcoin arguably became money under the UCC, and that would lead to all sorts of unanticipated outcomes that we don't need to go into in detail, but I'll talk a little bit shortly about one of those. But we had to remedy that problem. And the way we remedied that problem is to exclude from the definition of money an electronic record that was a medium of exchange that existed before it was authorized before the government authorized or adopted the electronic record as a medium of exchange. So because Bitcoin was already in existence before it was adopted by El Salvador and the Central African Republic as fiat currency, Bitcoin is excluded from the definition of money. Now, does that mean that Bitcoin is now out in the cold? No, it's still probably a controllable electronic record, certainly a controllable electronic record under Article 12. So the Article 12 rules would apply to Bitcoin, and you have the take-free rule, benefit, and everything else that would work. Now, then, if you also looked at the pre-amendments UCC, you'd see that there was no distinction between tangible money and electronic money, that you could have electronic money. Now, this would typically be what is referred to as a central bank digital currency that you see with the Bahamian sand dollar, and maybe the Marshall Islands, I think, has a central bank digital currency. So we thought that we would at least try to anticipate that there could be some sort of electronic money that could be token-based or account-based. Now, the reason that we had to deal with this is that under the pre-amendments UCC, a security interest in money can be perfected only by possession. And electronic money, being an intangible, cannot be perfected by possession. This was the real rub with El Salvador and the Central African Republic adopting Bitcoin as a fiat currency. It meant that Bitcoin was no longer a general intangible. It was money, and you can only perfect a security interest in money by possession. So those who were lending against Bitcoin had no way to perfect a security interest in the Bitcoin under the pre-amendments UCC. So now that Bitcoin is defenestrated from the definition of money and becomes a controllable electronic record, then we had to deal with a couple of other issues. Under the pre-amendments UCC, as I mentioned, you can perfect a security interest in money, presuming it's tangible by possession. So we have a control rule for perfecting a security interest in electronic money. We make a distinction, though. If the electronic money is in a deposit account, even one at a central bank, that the deposit account rules apply. These are the normal rules that you're all familiar with. It's only if the money, electronic money, is not in the deposit account, typically a token base, that you perfect a security interest in it by control. We also, under the pre-amendments UCC, had a definition for, had a rule that talked about when a transferee of money cut off a security interest in the money, and the transferee would usually take possession of the money because it was tangible. And now we say that if the transferee takes control of electronic money, it also cuts off the security interest in the electronic money. So all we were doing was trying to come up with parallel rules for electronic money to what we already had in Article 9 for tangible money, namely perfection by possession and describing the circumstances in which a security interest is cut off. Well, we did not expect to see an uproar over this. Some states have very grave concerns about central bank digital currencies being adopted in the US, and were really thought that we were creating rules in anticipation of a central bank digital currency much more than we ever could have envisioned. As I said, all we were trying to do was to adopt parallel rules for tangible money that were applicable to tangible money. But some states have stripped out the electronic money provisions so the money has to be in tangible form, and electronic money just becomes a general intangible. The only way you perfect a security interest in a general intangible is by filing a financing statement. So in those states, if there is electronic money, there may be a different treatment and some interesting choice of law issues. Mercifully, Virginia retained the electronic money provisions in the amendments, so Virginia will not have that issue. If there is a central bank digital currency, and if there's not a central bank digital currency in the US, it's a null set. So, Steve, changes to chattel paper.
Thanks. So while we were at it, we took a look at some of the rules for chattel paper and how they fit, and in particular the definitions for chattel paper to make, in part, to make things consistent with what we've got here in Article 12 and the revisions to Article 9 to deal with the controllable electronic records. The traditional definitions of chattel paper were a little bit awkward in terms of tangible chattel paper and electronic chattel paper. And what the drafting committee recognized is that what chattel paper really refers to is the right to payment evidenced by the chattel paper, but it's not, the chattel paper concept doesn't depend on whether it's tangible or electronic. The perfection mechanisms depend on that, but not the notion of what the chattel paper is. So the definition is revised to pick up the notion of the right to payment, and we'll talk in just a second about which rights to payment are covered by chattel paper. So the terminology has been moved around. The substance is really not different. It's the same set of concepts as you'll hear in a moment. So sometimes chattel paper, which includes a right to payment secured by specific personal property, specific goods, I should say, or a lease of specific goods. Sometimes those transactions are combined with some service elements. You might lease a specific car and also get a service contract from the lessor of the car or something like that. And there was some debate or lack of understanding on whether the chattel paper rules applied to that or not. Was the service component so great that it sort of undermined the status of a lease of specific goods? So we came up with a predominant purpose rule that says that if the predominant purpose of the lease transaction is to use the specific goods, then the chattel paper rule, it would be chattel paper, and the chattel paper rules would apply. The question of tangible versus electronic comes up later in terms of how one perfects a security interest in that chattel paper. Some non-uniform Virginia rules in this area were dropped. So Virginia now has the uniform version, which should facilitate cross-border in the sense of one state to another state transactions. So if the financier of a lease entered into in Virginia, governed by Virginia law, somebody leases a car in Richmond, and then the lessor wants to finance that chattel paper with somebody outside of Virginia, then we're going to have the same set of rules apply, and that should facilitate all these kinds of financing transactions. An additional definition of control, you have two choices now, was added. The existing definition just didn't work if chattel paper was held through some sort of distributed ledger technology because it would be harder to deal with the notion of a single authoritative copy. There are multiple copies in the distributed ledger, but there's one control. So as long as the one control is satisfied, and you'll see it looks quite a bit like the choice of law rules for the CER's jurisdiction, which Ed and I have been talking about throughout this program. Once you get familiar with those, you'll be familiar with the chattel paper rules. Again, here's a list of the rules. The control of a record has to identify each electronic copy as authoritative or non-authoritative, identify itself as the assignee, and here's those lovely words we see again: exclusive power for each authoritative copy to prevent anybody else from changing the assignee. If you go back and lay this down side by side with the definition of control in Article 12, you'll see it's very similar, but adjusted or tailored to the notions of chattel paper. The same multi-signature rules or comparable multi-signature rules for control that I briefly mentioned before would apply to chattel paper. And again, we strongly recommend looking at the comments to the meaning of control, and in particular, the illustrations in the comments for these multi-signature relationships, which walk you through the sort of a matrix of ways that might exist in these transactions. As I mentioned before, we got rid of, the amendments get rid of the phrases tangible chattel paper and electronic chattel paper. Instead, it's chattel paper in electronic form. It's chattel paper that is tangible, but chattel paper is still itself the right to payment. If a chattel paper is perfected by possession and or control, we have the same non-temporal priority that existed today under several subsections of Section 9330 of Article 9. So structurally, those involved in these industries who generate or buy and sell chattel paper will be readily adaptable to the revised rules as we work our way through this, and have enhanced the methods for dealing with chattel paper in electronic form. The choice of law rules themselves mirror mostly the choice of law rules for CERs. If the terms of the chattel paper themselves expressly refer to a chattel paper's jurisdiction, so it is. If the system on which the chattel paper is maintained expressly refers to the chattel paper's jurisdiction, then that's it. And we go down the waterfall. If there's a general choice of law term in the chattel paper, then that's the chattel paper's jurisdiction. If the system has a general choice of law rule, that's the chattel paper's jurisdiction. And then the one change from CERs, which default in the absence of the application of the higher levels of the waterfall to Washington, D.C. Instead, it refers to the location of the debtor for these purposes. And again, once all of the United States has all of these rules, it's not going to matter. And then for chattel paper in tangible form, the location, the physical location of the authoritative copy of the chattel paper. There's some discussion of what authoritative copy means in the comments. And again, be sure to read all that. Again, for purposes of perfection by filing, the location of the debtor continues to be the rule for perfection. But again, like CERs, even though you perfect by filing a financing statement, the debtor's location, priority of the security interest, even when perfection was not by control, but was by filing a financing statement, is governed by the chattel paper's jurisdiction. So Ed and I are now going to run through some miscellaneous other amendments to the UCC, which you'll want to know about, and Ed will start with electronic documents.
Yeah. I'll just mention these briefly. There is a additional safe harbor for control that tracks the additional safe harbor for chattel papers. So you could have, let's say, distributed ledger technology for transferring electronic documents. For negotiable instruments, we make it clear that a choice of law clause and a choice of forum clause does not affect negotiability. This is useful for transferable records, where you need to make sure that the information on the transferable record would render, if it were in writing, a negotiable instrument. So you can have a choice of law clause and choice of forum clause in a transferable record without affecting the fact, destroying its negotiability. There is a provision that says that you can transmit, that a maker or drawer may create an instrument by transferring an image of the instrument if the information would permit the issuance of an electronic check under Reg CC. And then in the situation where I do a remote deposit capture, I send in my deposit my check remotely in a bank, and then I tear up the instrument, but something goes wrong. That doesn't discharge the obligation embodied in the instrument.
And we might mention here, a question came in about, how about Articles 4 and 4A? Are they left out of all this?
Well, they're not left out, but there's only a minimal treatment here. On payment systems, 4A, we make clear that if you're dealing with a reasonable security procedure, that can include symbols, sounds, or biometrics, but not an email address, an IP address, or a phone number. And Article 4 was really not touched. So, Steve, a few other miscellaneous amendments.
Okay, so we've got in Article, did I go too far? No, I didn't go too far. Articles 2 and 2A, similar to the chattel paper discussion before, there's some amendments to clarify how a hybrid transaction, when it's in, is it in Article 2A as a lease of goods or not? Roughly speaking, there's another predominant or primary purpose test for these transactions, and then sort of a residual safe harbor that says, well, to the extent there's an issue that doesn't involve the sale or the lease of goods as such, we can look to other law to determine what the legal aspects of are. That we struggle a lot with this, and it's a sort of apply in a sensible way, Article 2 and 2A or other law in these transactions. And Article 5 and 9, more.
Well, let's do Article 9. With the definition of sign now being expanded to include an electronic signature, we delete the word authenticate in Article 9. You can go back to the old colloquial way of saying, referring to a security interest signed by the debtor instead of authenticated by the debtor. Let's go on to the next slide, Steve. We made it clear that the provisions of Part 4 of Article 9, when it refers to an assignor, means someone who sells the right to payment or grants a security interest in the right to payment to secure an obligation. Either way, this overrules some cases that have just gone one way or the other. And then on proceeds of commercial tort claims, we've made it clear that you don't need to describe proceeds of a commercial tort claim as proceeds. You do need to describe it as original collateral, but if, let's say, you have a piece of equipment that gets torched by someone and there's a claim against the tortfeasor, that commercial tort claim would be proceeds of the equipment of the original collateral, and that doesn't need to be specifically described, nor if that case is settled, does the settlement agreement need to be specifically described. Well, we only have very brief time for transitional rules. So Steve, over to you.
Okay, I'll just spend a moment on this. The transition rules provide that on the effective date, it becomes effective. So if before the effective date a secured party took steps for control, they didn't have control yet, but on the effective date, they would have control. But in terms of priority, if before the effective date, a secured party had established, that's the word, its priority. Secured party 1 filed a financing statement. Before the effective date, secured party 2 got the elements of control, but control didn't exist. So it was junior. Secured Party 1 had established its priority, and for 1 year after the effective date until the adjustment date, Secured Party 1 still has priority. Then the control of Secured Party 2, which popped to life on the effective date, obtains priority on the adjustment date. But if Secured Party 1 before the effective date files a financing statement and there is no competing secured party, they have an established priority over anybody. And if the day after the effective date, Secured Party 2 gets control, then they immediately have non-temporal priority in all of the CERs that they've had got control of after the effective date, because there was no establishment of control before the effective date. Pretty complicated stuff. It'll go away after a year or so. So why don't we go to the status, Ed?
Well, these are the states that have already adopted the amendments, and we have other states that have not. So, Steve, why don't we go to the next slide? You can mention the PEB report.
Yeah, so the confluence of these transition rules and these new choice of law rules are really complicated. The permanent editorial board that Ed mentioned, which he and I are on, has put together what we think is a helpful guide, including words, charts, flow charts, all sorts of stuff to help you deal with this during the next couple of years, when some states will have the new law and some states don't. This takes you all the way back to choice of law that you had in law school. You're welcome to look at the commentary. It's been approved by the PEB, but it's not yet final because I'm the reporter and I have to make a few edits here and there. But it's real, and everybody, including choice of law experts, have approved it. There's a link. It's in front of the paywall, so no cost, and you're welcome to download it and peruse the words, the charts, and the flow charts. So, Ed, I think we've come to the end. Any final comments?
No, I think we probably exhausted our audience too. So thank you all for bearing with us. And we look forward to July 1, 2025, when these 2022 amendments are in effect in Virginia. And hope all of you will be totally up to speed and that we've helped you do that in this program.